Al, are you there?
Lindsay, can you hear me now?
Yep, I can hear you.
Okay. So I will go back and welcome everybody once again to Local Media Foundation's webinar for today. My name is Al Cupo, Vice President for LMA, and joining me as our moderator is Gareth Charter, Local Media Foundation's Director and LMA's Marketing Committee Chairman. Today's webinar is titled The Legal Minefields of Native Advertising. I want to mention that this webinar is made possible through a grant from the John S. Knight, James Knight Foundation. I want to mention also that this is just one of course, many webinars that we have throughout the year, and that you can go onto our website, localmedia.org, for a complete list of upcoming webinars. You'll also find that we archive our webinars as well on that site. I want to mention that we do have a couple upcoming events, and particularly because these upcoming events do address native advertising. The first one is our LMA and Blinder Revenue Summit. It's taking place in Chicago, May 21st and 22nd. And we just announced the one-day Native Advertising Summit in partnership with BIA Kelsey. That program is scheduled in the DC area on July 9th. We, of course, encourage you to follow us on Facebook and Twitter. And while you're visiting these sites, be sure to read about LMA's new local media class of membership and enter LMA social media contest by using the hashtag #JoinTheInnovation. A couple notes about our sales training program. We've just added a new digital business development course to our media sales certification program. And we also offer Google AdWords certification training that's offered both online and on-site. You can read more about both of these programs on our website. In addition, we have a couple new reports that were just released through our foundation. The first one is Can Hyperlocal News Sites Make Money? And the second, titled Social Media and the Future of Audience Development. And now a few housekeeping issues regarding this webinar. Like all of our webinars, you are welcome and encouraged to ask questions at any time. Simply use the box on the right-hand side of your screen, the Go to Webinar box, and type your question into the question area. And we'll answer those questions as we can throughout the course of the webinar. When this webinar is completed, you will receive a survey from Local Media Association. We encourage you to fill out that survey and provide feedback to us, including if you have any ideas for upcoming webinars throughout the year. Now, I did mention that we archive our webinars, and we are going to be able to archive this webinar as well. In fact, we will send you an email letting you know how you can access that file right off of the Local Media website. And now I'd like to go ahead and ask Gareth Charter to take over and introduce our speakers for today's webinar. Gareth?
Thank you, Al. I want to thank everyone and say good afternoon to everyone for joining us here today. And I want to also thank again the Knight Foundation, which makes this series of webinars possible for them to be free to all our participants. This webinar series is entitled The Innovative Audience Development, and this is the first in that series. 2 weeks from today, on April 24th, at the same time, 3 p.m. East, we will have our second in the series, and that will be entitled Multi-Platform Journalism and a Look at an Online Radio Station. We're going to take a look at a Metro daily newspaper that has launched its own online radio station. Next up after that, yet to be scheduled on an exact date yet, but we'll be doing a webinar on participatory or citizen journalism and how the citizen journalists are interacting with the professional journalists, and a lot of thoughts on where that's going in the future. As Al mentioned, we welcome ideas that anyone might have on this series, and you can reach us through the LMA website. So I want to get us going here on the legal minefields of native advertising, and want to thank our presenters today, Rob Bertsche and Asya Calixto from Prince Lobel in Boston. Rob is a media and First Amendment lawyer with a national practice. Rob offers counseling and litigation services to media clients throughout the United States, including magazines, newspapers, book publishers, broadcasters, website operators, bloggers, filmmakers, and advertising and public relations agencies. Rob's clients range from a multinational publishing company to the solitary blogger, from the television talk show host to the cartoonist, and from the documentary filmmaker to the community newspaper publisher. Much of Rob's day-to-day work involves protecting his clients from litigation. A former newspaper and magazine journalist, he is dedicated to helping journalists practice their craft aggressively and responsibly without courting undue legal risk. He has conducted pre-publication review of thousands of newspaper and magazine articles, as well as nonfiction books on politics, business, ethics, and even cooking. He's also served as legal counsel. He's also served as legal counsel to the New England Newspaper and Press Association, where he established and oversees an active legal hotline for 300-plus community newspapers that are NEMPA members. Since 2002, the New York-based American Society of Magazine Editors has selected Rob to provide its annual business and editorial law training for staff of print and online publications. Before attending Harvard Law School, Rob worked as a city editor of the Daily Transcript and Telegram in Holyoke, Massachusetts, and he attended the Radcliffe Publishing Procedures course in Cambridge, and he was the editor on the founding staff of New England Monthly Magazine. Asya Calixto is a lawyer in Prince Lobel's media and intellectual property groups. She does business work and litigation for a wide range of media and advertising clients, among others. Her regular clients include Family Circle and Parents Magazines, the New England Newspaper and Press Association, and the muckrock.com public record site. She is founder and chair of the Russian Lawyers Association and co-chair of the International IP Committee of the Boston Bar Association's Intellectual Property Section. Most recently, Asya has been named by Massachusetts Lawyers Weekly as one of the up-and-coming lawyers of 2014. She's a graduate of Northeastern University School of Law, where she was symposium editor for the Law Review. So with that, I'd like to turn it over to Rob and Asya and let them take us through this. And again, if you have questions, use the chat box there, and we will get to them in due time. Rob?
Thank you very much, Gareth, and thank you, Al, and thank you to the Local Media Association and the Knight Foundation for making this all possible. I'm going to give some introductory remarks, and then we're going to get to the hard stuff, which I'll turn over to Asya. I find this a particularly interesting area of the law and of journalism today, because what we have is two conceptually different, legally different fields that are getting increasingly blurred. And what that means is that we have to be imaginative and creative when we think about how the law applies to those things. What do I mean by that? Well, you know, there's always been a funny relationship between the advertising and edit sides. I remember when I worked at the Transcript Telegram in Holyoke in the early 1980s, we made it on the editorial side a point of honor that we barely looked over the wall to the advertising people, and we certainly didn't go out to the bar with them on Friday evenings, and we didn't associate with them. That wall was pretty darn high, and it really was a point of pride for all of us. I remember when not so long ago, the New York Times and other newspapers started to put ads on their front pages, which they hadn't done throughout my lifetime. And the number of people who were aghast, this is a sign of the death of journalism, they said. Of course, those who were the old-timers among us said, oh no, they could remember the times when the ads were on the front page. And of course, there's a long, long history of advertising and editorial being mixed all together. Everything from the Geritol commercials that you saw on Ted Mack's Amateur Hour to all sorts of blurring and commercial endorsements in television, but in print as well. So it's never probably been for all time as pure as we would like the division to say it ever had been, but it's certainly not today, and there is a blurring between advertising and editorial, and that's of interest to those of us who work in this field as lawyers for a number of reasons. First of all, when you're dealing in the pure editorial world, the newspaper is going to try to get the content right. You always want to be selling accuracy to your readers, and that's a lot of your goodwill with your readers comes from the fact that you are accurate. But the fact is, newspapers can't be sued for can't be successfully sued. This is America, they can always be sued, but can't be successfully sued simply because they published false content. So if you get something wrong, you don't have to necessarily worry in and of itself that you're going to be the defendant in a lawsuit. If you have the ingredients wrong in that recipe and somebody suffers harm, you will probably not be on the hook for the fact that you gave them baking powder instead of baking soda to put in those muffins. If you publish the book about a guide to edible mushrooms, and there was such a case, the Putnam case, and somebody sues you after following your advice and eating one of those supposedly edible mushrooms and getting sick and finding that they actually weren't so edible after all, that you got it wrong. Again, the law says you will not, absent some sort of warranty that you've given to your readers, you will not be responsible for that and you won't be liable. The exception would be something like Good Housekeeping, where they've actually set out a seal of approval and told people that they've gone through a rigorous testing process and that sort of thing. Now, of course, there are ways you can be sued when you get things wrong. For example, if you hurt somebody's reputation and say something false about them, they can sue you for libel. But the falsity by itself isn't enough to create a claim. That's the truth in the editorial side of the world. What about if you're publishing an ad? Well, I should say the other part in the editorial side of the world is that you can take a picture of Jimmy Fallon when he's walking down the street in your community, and you can run it on your front page with an article about Jimmy Fallon, and you can run it on your front page because you think more people will buy your newspaper if Jimmy Fallon's picture is on the front page. And you have every right to be doing that when you're doing it in a news context. Different when we go over to the advertising side. What you can't do with Jimmy Fallon's image is you can't put it on your cereal box to sell Jimmy Fallon flakes and thereby be using his picture, his name, his likeness in order to sell a commercial product. Likewise, let's talk about the mushrooms. In your ad, you can't say these mushrooms that we sell are edible mushrooms if in fact they are not edible mushrooms. You may have some liability there for a number of reasons, including some that Ozzy will get to in a few minutes, dealing with the Federal Trade Commission Act, which regulates unfair, deceptive, and misleading content. So the falsity won't get you into trouble when you're in that pure editorial world, but it may well get you into trouble when it comes to advertising. And we've had over the years a number of cases where that line has started to blur a little bit. And just to give you some background, I want to tell you about one or two of them. In early 1980s, New York Magazine had a column, the Best Bets column. And they had a picture of a model wearing a jacket. And the editor of the column decided to feature that jacket in the column. And they included in the column, here's the store where you can buy this jacket, and here's the price that you can get it for. The model sued New York Magazine. He said, look, I gave you a release to use my image, but only to use my image in an editorial context. I didn't give you the right to use my image in advertising. The magazine said, well, whoa, this was an editorial context. We were writing about this particular jacket, where it could be bought, where it could be sold, etc. The model said, no, you're trying to sell that jacket, and that manufacturer, in fact, is one of your advertisers, let's say, he said, and that makes it advertising. The court had to decide which was which. In that case, they decided that because neither the manufacturer nor the store had actually commissioned this piece, they didn't have anything to do with the use of that photograph by the magazine, then there was no evidence that they got any kind of kickback for it, that they got extra money from the magazine because of the use, or that they got any, we didn't have it back then, but sort of pay-per-click remuneration. And because of that, the court said, There was no purchasing, no promise to purchase advertising. This would be considered an editorial use, and there is no claim. New York Magazine had the absolute right to highlight that jacket and even give the helpful advice about how it could be used. Think about, and we'll talk about later in Asya's section, whether that same thing would hold true if you are clicking to, you're asking your readers to click, go to the store where they can buy it. They then can put in their credit card number, buy that jacket, and some percentage or commission goes back to the newspaper that originally piqued the reader's interest. Maybe then we've got a different result, and maybe then a court would decide that that is advertising. A couple of other cases that have come up along the way, many of these cases centering in California, the land of celebrities. One involved Dustin Hoffman. He was featured in a fashion spread in Los Angeles Magazine that was called Grand Illusions. And the idea behind the fashion spread was to take old classic movie stills and then use the miracles of Photoshop and that sort of thing to dress those old actors in modern fashions. And so they took Dustin Hoffman from, what was it from? I'm blanking on from the movie in which Dustin Hoffman is dressed up as a woman. And I can hear you all shouting it out to me right now. But anyway, Mrs. Doubtfire. No, that was Robin Williams. I'm going to make a fool of myself now. I better stop. But it was Dustin Hoffman dressed as a woman, and they put him in new modern fashions and showed him in their fashion spread. And Dustin Hoffman sued. And he said, this is a violation of my right of publicity and a defamation of me. He said it was a violation, Tootsie, thank you, Gareth. He said it was a violation of my right of publicity because essentially by showing that picture of me in a fashion spread where all of the fashions are advertisers in the magazine, you're not really using my picture for an editorial purpose. You're using it for an advertising purpose. And if you're doing that, you can't do that under the law without my express written permission. He also said, incidentally, that it was defamation because he said it would have to be an actor way down on his luck who would agree to pose for Los Angeles Magazine fashion spread. And so the mere suggestion that he was so down on his luck hurt his reputation in a respectable segment of the community. Well, the court took a look at Dustin Hoffman's claim, and the court was very impressed, apparently, by Dustin Hoffman. The very first words of the decision were, Dustin Hoffman is a living national treasure. You can imagine where it went from there. The judge said this was a unjustified commercial use of his image. Los Angeles Magazine appealed to the Ninth Circuit Court of Appeals, and the Court of Appeals reversed. They said, no, in fact, this was an editorial use. You're allowed to use Dustin Hoffman in your fashion spread where you are commenting on the original movie stills, just as you're allowed on the cover of your weekend magazine to put somebody's picture because there is content inside the magazine about them. Even if your motive for putting somebody on the cover of that Sunday magazine is that you think you may sell more copies, so long as you've got editorial content that it pertains to, that's going to be considered an editorial use. Well, the next case along those lines that came along was one brought by a fellow by the name of Jose Solano, who was an actor on the Baywatch show. And Jose Solano was featured on the very front of Playgirl magazine. And he was right next to a headline blurb on the cover that said something like, bottoms up, hot celebrity buns. And then in the lower right-hand corner, Baywatch's best body, Jose Solano. Well, somebody who bought Playgirl magazine in the hopes of seeing more of Baywatch's best body, Jose Solano, was going to be sorely disappointed because when they finally paged through the magazine, they would find only one small squib about Jose Solano, and it shows just a publicity headshot of him and a couple of words. Oddly enough, this case goes to the same judge who originally decided in favor of Dustin Hoffman. Having learned from his mistakes, that justice ruled in favor of Playgirl magazine and said this is a protected editorial use. Jose Solano now appealed, and once again, this same poor, misbegotten judge was reversed by the Ninth Circuit Court of Appeals. Here they said there was so little editorial content inside that Playgirl magazine was liable because essentially they were, it was a bait and switch. They were selling you the magazine as if you were going to get Jose Solano's best buns, and in fact all you got were the cheeks on his face. And they said that is false advertising, essentially, and held that that was a violation of Jose Solano's right of publicity. Probably matters in that case that the way they sell Playgirl magazine is in a shrink-wrapped package, so there was no ability of a buyer to test the wares before they bought. It was only after buying Playgirl magazine and opening up the shrink wrap that you would understand that you weren't going to get as much of Jose Solano as you might have originally thought you were paying for. So this brings us to the world of native advertising. Lots of definitions of this. We took this charticle from Mashable, which says native advertising integrates high-quality content into the organic experience of a given platform. As a form of content, it does not interrupt the flow, and it's equal with user interaction. And it will be shown by things like sponsored by or promoted content or sponsored content. And you'll find it in promoted tweets, you'll find it in sponsored stories on Facebook, in paid discovery and stumble upon. The challenges, well, they talk about a poll of more than 200 media buyers between 2012 and 2013, and the average increase in expected native ad spending between those 2 years was 12.5%. 57% of venture capitalists, private equity firms, and angel donors say they're likely or very likely to invest in companies that sell native advertising. 34% of publishers say they're likely or very likely to add a native advertising option to their menu. And I suspect that that number has increased over the passing year, and probably is what has many of you on this teleconference as well. So what is the problem when we're dealing with native advertising? Well, the problem is, what are the rules that are going to apply? Are we now dealing with the rules of editorial, or are we dealing with the far more regulated context of advertising? Now, some years back, Rolling Stone decided to do a gatefold, double gatefold, indie rock universe, an alternate dimension where everyone wears black Converse, and this was a pay-in to all of the indie bands that are out there. And they got Camel cigarettes as an advertiser to help sponsor this butterfly gatefold, and they featured inside a number of independent musicians. And when you open the original pages, you can open them like French doors and see an editorial feature consisting of 5 pages. So here we open up and we see Camel, the farm, committed to supporting and promoting independent record labels. The best music rises from the underground. And you'll notice in the left-hand corner there, the Surgeon General's warning. If we didn't know it was advertising before that, we know that's an ad now because they put in the required disclosure. The FTC can't make you put that kind of speech into your article. You can write an article endorsing how wonderful it is to smoke cigarettes, and the FTC cannot make you add a Surgeon General's warning to it. But they can make you add a Surgeon General's warning to your advertising. the same concept we've been talking about, the high protection for First Amendment or editorial speech, the relatively lower protection for advertising or commercial speech. Well, to make a long story short, the issue in this Rolling Stone cover was the upset of a number of the different independent bands, Lupus Major, Animal Planet, Space Jam, who were highlighted in this Butterfly Gatefold feature, who said, by putting us in association with the Camel cigarette ads, it looks like we, in fact, are endorsing the sale of cigarettes. And that's absolutely antithetical to everything that we believe in. So they sued. And the question before the California Court of Appeal was, is this advertising? Is this a commercial use of the independent band's names to sell a product? Or is this, in fact, protected editorial speech? The trial court had originally concluded that this was commercial speech, that this was like an ad. But the Court of Appeals took a look at it and came otherwise, and decided that it was non-commercial speech as a matter of law. That was in part because they said the magazine, although it's engaged in commerce, is not engaged in the production, distribution, or sale of cigarettes. Quoting from the decision, Rolling Stone magazine is primarily a periodical commentating on events of political and cultural interests of the day. Its articles critically assess these interests. They say, well, the plaintiffs, the indie bands, claim that it's hard to tell where the ad begins and where the ad ends. And the court says, we've looked at the pages closely and we don't perceive that that distinction is so close as they allege. We think you can, a reasonable reader can. A reasonable reader can tell the difference. They also say we don't find the fact that the intro page of the feature is not in the standard typeface of Rolling Stone to be determinative. And so ultimately, excuse me for the pauses, I'm getting over a cold. They determined that this was in fact protected editorial speech and that the plaintiffs did not have a claim. You may recover and recall another famous botch example of sponsored content, and you can see at the top of this page, it says sponsored content. This is something that appeared in the Atlantic magazine in the early days of native advertising. David Miscavige leads Scientology to a milestone year. Under ecclesiastical leader David Miscavige, the Scientology religion expanded more in 2012 than in any 12 months of its 60-year history. It's a paean to Scientology, made understandable only when you understand that it was paid content for which the Scientology founders or organization had contributed funds. It may have seemed odd to have the sponsored content, but there was fairly clearly denoted there on top, sponsored content in that yellow box. And you'll notice next to it that little "what's this?" Ozzy will talk about that in a second. But then when you look at the comments on the piece, those were what were most quizzical. Kiwi Boy, seems like David Miscavige and Scientology are on a roll. Also, it appears the media have been missing the real story. Somebody else, I had no idea Scientology had all those churches. Respect, to each his own. Emerson Watts, this is a great account of the great developments happening in the Church of Scientology today. Well, those of you who have opened up your news columns to reader comments, I'm sure are aware that that kind of praising, uplifting speech is not typical of the comment section. And sure enough, it appeared that somebody in the marketing department at The Atlantic, excuse me, was picking and choosing comments, or maybe creating comments in order to promote these. This was a major embarrassment, not a legal problem, but a major embarrassment for The Atlantic. Which you'll see temporarily suspended the campaign pending a review, and then later issued an admirably candid statement: "We screwed up. We now realize that as we explored new forms of digital advertising, we failed to update the policies that must govern the decisions we make along the way. It's safe to say that we're thinking a lot more about these policies after running this ad than we did beforehand. In the meantime, we've decided to withdraw the ad until we figure all of this out." So the point of today's teleconference is to help you do exactly that, so you don't have to make this sort of public apology. And my colleague, Asya Calixto, will take you through some of the ways to be sure you are not in that position.
Thanks, Rob. So Rob has indicated to you that this has sort of set up this world of commercial speech, and I'll talk to you about the role of the FTC and some of the best practices that are emerging in this area. So now that we are in this world of commercial speech with native ads, and the FTC is playing a role. It's overseeing content because it has the authority to impose certain requirements when it comes to commercial speech, even though it can't impose those same requirements when it comes to just purely editorial content. And the FTC is empowered by Congress to protect consumers against unfair and deceptive content. Based on what's referred to as Section 5 authority, the FTC can take action when it finds that content is either unfair to consumers or it's deceptive in some way. The role of the FTC, in essence, is to make sure that commercial content is truthful, that it's not misleading to readers. For native advertising, just like for any other type of advertising, there are three basic principles that apply. The first is that ads must be truthful and that they cannot be misleading. Publishers have an obligation to provide information to readers both about a product or a business that's being marketed and about any bias that might impact how readers are perceiving the ad. If, for example, you have a local farm that wants to place a native ad, let's say a recipe in your publication, and the recipe calls for mushrooms that specifically grow in that farm, consumers have the right to know, says the FTC, that the farm has paid for that ad, that the recipe is biased in the farm's favor. It calls for those specific mushrooms, not because that's the neutral opinion or suggestion of the writer or of the publication, but because the farm has paid for that opinion to be conveyed to readers. The second principle of advertising law is that claims must be substantiated. This means they must be backed up. A publisher has to have support for claims that the advertisement conveys. So if you have a mushroom ad and you want to say that the mushrooms are very high in vitamins, you have to have evidence to support that. And finally, the ads must not be unfair. The content that's unfair is content that's likely to cause a consumer injury if the consumer could avoid that injury if they knew all the facts, if they had all of the facts that were relevant to that product. So an ad should not be making a false statement, and it shouldn't be omitting a statement that would be important to a consumer's decision to purchase a product. If the mushrooms help readers to lose weight, that fact must be true, and it also must be true that you don't need to do other things like exercise to reach those results. In other words, all the criteria should be disclosed. So unlike with editorial content, when you're selling something, the government will watch over what you present and how you present it. It wants to make sure that these three guidelines are complied with and that consumers aren't being misled. Now again, those guidelines apply to all forms of advertising. It's nothing new, but when it comes to native advertising, there's a particular problem that's posed, and that is that when there's a push to make ads feel less and less like ads, consumers often can't tell the difference between what's editorial and what's commercial content. And when they can't tell the difference, they can't accurately judge the content. They would, if they knew that the content was sponsored or paid for by a company, they would treat it differently than if they thought that the content was coming from a reporter. And so that's the boundary that we're dealing with. And to address this, the FTC held a forum this past December. They wanted to hear from people in the industry what they were doing about native advertising and to get a sense of what was actually confusing to consumers and to readers. One question that was posed at the forum, and a question that you're probably wondering about, is whether the FTC even has the authority to hold a publisher rather than an advertiser accountable for ad content. And the FTC thinks that it does. There hasn't been a challenge to this yet, but the FTC does think that it can hold publishers accountable for violations of these three principles. As an aside, this might not be an area in which we think that the FTC should or needs to have control. Some argued during this forum that the industry is self-regulating, and we'll discuss some best practices that have emerged from industry standards in just a little bit. But there are examples of the industry self-regulating itself. The idea is that the interests of publishers and advertisers are aligned with consumer interests, and that's the interest in transparency. Companies don't want to look like they're tricking people into buying their products, and publishers don't want to lose the trust of their readers. A recent example of this is a UK flower company that put out about 150 advertorials last February, right before Valentine's Day. And this was in an effort to get placed higher in Google search results than their competitors. Google found out about it, and they booted the flower company from Google search results for 11 days. So Google actually monitors native advertising and weighs it differently than it does editorial content. So that's one example of a sort of natural industry disincentive to try to be deceptive to consumers. But whether or not we think that the FTC should be in this field, the fact is that the FTC could very well take some action here, and for that reason, it's a good idea to be aware of what the FTC is concerned with. And it's really concerned with two questions. The first is, at what point does a company have enough influence on certain content that's produced by a publisher that readers actually need to know about it? When is it misleading to not identify content as something that's other than pure editorial content? In other words, when are disclosures necessary? When is an ad an ad? And once we've decided that something is an ad and that some form of disclosures are necessary, the second question is, how should that disclosure be implemented? In other words, what's the most effective way to let readers know that the content is not purely editorial? Now, taking the first question, what are we protecting readers from? We need to determine the circumstances under which an editorial is no longer an editorial. What readers need to know about the content that they're reading, and at what point is it that they must be made aware that there is a third party, some sort of company or business interest that is that's being addressed in the content. And there are three factors that come into play in the construction of an article. These are triggers that require a disclosure in some cases. The first question is, who created the content? Who's doing the talking? Readers need to be able to distinguish between the voice of the publication on which they rely to provide them with unbiased content from the voice of companies that are trying to get readers' attention and get their interest and have an obvious stake in how their products are being perceived. And think of this as a spectrum. On one side of the spectrum, we have editorial content that's conceived of and written by the editorial staff. But moving closer to the advertising part of the spectrum, what if a company suggests that a certain story be written about, a certain topic be written about? What if that happens without any sort of oversight from the company? that seems to be closer to the editorial side of the spectrum, but the more impact or influence the company has, the more it shifts to the other side. What if the content is run by the company for approval before it's published? Now it's looking more like an advertisement. It's looking more like a piece that's commissioned by the company. The American Society for Magazine Editors takes on this question, and their position is that editors should not be writing ads, period. That's a conflict of interest. And advertisers should not be approving editorial content. If you do decide to do that, that's something that needs to be disclosed. That's something that readers should be able to know about. Another approach is to take that some people take is to get third-party vendors to create native ads, and that way the ads are created by people that are separate from the editorial group. So we're avoiding that conflict of interest. But in that case, still, a reader should know that the publication staff is not the voice. It's not doing the talking. It's another third party that's doing the talking, and that's a disclosure that needs to be made. The second question is who paid for it. Is the content produced at the expense of the publication, or is it produced at the expense of a company? If the latter, then readers will look at that content more critically, and they will know that they need to be sensitive to biases about the conclusions and messaging of that piece. So let's say there's content that's written by the editorial staff with no oversight, but it's paid for by the company. It doesn't matter whether that payment happens before the article is written or if the article is written first and then the company pays for it later. If it's already written before the payment comes into play, then maybe a disclosure isn't necessary, you might say, but I think the FTC would disagree. Maybe it's not strictly an advertisement in the traditional sense, but if it's paid for by the company is having some sort of influence on the substance of the article, and that's an involvement that needs to be disclosed to consumers. Some argued during this FTC forum in December that the word sponsored means that the content is underwritten, not necessarily that it's created by the company, but that the company is supporting it in some way. And so that's one way to indicate that, that there's been some sort of financial exchange that has supported the creation of certain content. And the same theory applies for links that are paid for. Even if a link is to content that was created without any involvement from any company or business, the fact that the link appears on a certain website is due to a payment made by a company, and so that would need to be disclosed as well. Now, the third question is one that I find particularly interesting, and it deals with what is the content. Is the product or a company name even mentioned? And that matters when it comes to how that content is perceived. A company has a stake in how their products are perceived, but also a stake in how the world is perceived in some cases. And even if there's a soft marketing campaign where there's no mention of a brand or a company name, sometimes a disclosure is necessary. I'll show you an example. I came across this piece on Mashable the other day. It's a list of heartwarming stories that prove that dogs are man's best friends. So it has 5 of these examples. Dogs are helping save lives, even children's lives, and this is great. It's all, you know, this list of 5 things, and I'm going through it, and I don't see any mention of any brand or company or anything like that until I get to the very end of the piece. And then in the topic section where certain topics are tagged, I see the word Purina. So this article was paid for as an ad essentially for Purina, and I did some digging after I saw that. Multiple sources have reported that Purina did in fact pay for this content. Purina seems to have an interest in building up people's perceptions about dogs, but since its name wasn't really mentioned in the piece, the question is a disclosure necessary? You'll notice that there is no disclosure in this particular piece. The question that we talked about before is whether a content will impact a person's purchasing decision. And here, there's no product really associated with it, but on the other hand, would Purina have ever sponsored this type of content if they didn't think it was going to make people purchase their products more? And so when you think of the takeaway, the alleviating people's confusion about the independence of an article, especially when it impacts purchasing decisions, I would think that a disclosure would have been helpful here, and not in this topic section, but more in a more conspicuous way. I don't even know if this sort of tag at the bottom counts as a disclosure, but I think it's pretty safe to say that it's not a very effective one. And so I want to move into now talking about what an effective disclosure is and what the best practices are when it comes to that. First, I want to take a high-level look at what's required in making the high-level disclosures. So once we've determined that something is an ad or is sponsored in some way, a disclosure is required, what do we do now? You'll find that a lot of these guidelines are guidelines that are generally recommended for all advertising, whether it's native ads or not. But there are a few new issues that are presented by native advertising, particularly when it comes to what the most appropriate labels are for designating this type of content. Effective disclosures are not a new concept for the FTC. The FTC has long-standing guidelines for effective disclosures, both in print and on digital platforms, and these guidelines require clear and conspicuous notices. And the FTC defines clarity and conspicuousness by several different factors. The first is where the notice is placed. Is it near the top of the piece, or is it buried somewhere at the bottom of the page? Second is the prominence of the notice. Is it avoidable? Are readers likely to ignore it, or do they actually have to navigate away from the notice before they get to read the piece? Third are distractions from the disclosures. If there are pop-ups, moving graphics, if there are arrows that point away from the disclosure, those would factor into whether that disclosure is effective. And finally, whether the language of the disclosure, the content itself, is understandable to the intended audience. And the language might be different in print, online. If it's on Twitter, it'll be less language, obviously, than if it's on other platforms. The idea is that for the audience that's reading that language, whether that's sufficient to alert them to the fact that that content is an ad. Taking a look at industry best practices, it's clear that there's this emphasis on transparency, an emphasis on making it easy for a consumer to distinguish between editorial content and advertising content. And the purpose is to effectively differentiate this type of content so that it's clear for readers. ASME recently amended its guidelines to address native advertising, and they have a few pointers I just want to bring up as ideas about how to make effective disclosures. The first is that ads should not imitate editorial content. It should be in a different type font. It should have different graphics. It should look different than the normal content that's on the website. Second, the ads should be labeled as ads and not as editorial content, and those labels should be prominent. They should be horizontal. They should be centered at the top of the page. They should be readable to people that are looking at it. And in a similar vein, the Interactive Advertising Bureau has similar guidelines that go to making sure that the disclosures are conspicuous, that readers are aware that certain content is paid for by a consumer. So I want to go through a couple of examples to see how this actually plays out. I'm going to show you.
If I could just jump in one quick second. We did get a question that's relevant to this. Someone's asking, is it okay for editorial to edit or review the content if they're not actually writing it?
There is a school of thought that the editorial staff shouldn't be involved in advertising content at all, but that's not a hard and fast rule. I think the important part is to make sure that it's clear to readers that that it's advertising content, whether or not it's being reviewed by the editorial staff or not.
Obviously, that line is going to be harder to draw in a small newspaper, for example, where you don't have that many people around, and the functions between news and advertising are already mixed somewhat.
So I'm going to show you two different pieces from BuzzFeed, and I'm just going to give you a few seconds to take a look at one and then the other, and then we're going to do a bit of a comparison. So this is the first one. And now I'll show you the second one. Now, as you've probably guessed, one of these is editorial content and the other is an ad. Now, when we're comparing these two, I want to look at the visual cues that we get from how the content is laid out and also for labels. Labels being a label saying that this is an advertisement and this is not. Now here, there are no labels. The second piece that I showed you was an ad, whereas the first one was an editorial piece. They're both about PlayStation, and they're both in a similar vein. They're reviews. The second piece does not say sponsored content or anything like that on there. It is very similar in terms of its layout, in terms of the heading, the title of the piece. The byline is similar. The graphic with the text underneath, it looks a lot like the editorial content on that website. The difference that you'll see is that the byline in one case are people, and in the second case it's Sony that actually wrote the piece. And that's really the only notation that I could see that identifies the second article as an ad versus as editorial content. The New York Times, since launching its native advertising initiative in January, has taken a very different approach and a much more conservative approach. And this is how native ads appear on their site. You see where that red arrow is a blue box with clear branding. It says Dell at the top. It says paid post in block letters. And once you click on that, you get to a page like this where you see that the article says paid for and posted by Dell. There's clear branding in two places, and the logos, if you click on them, will go to the Dell homepage, much like they would in a banner ad. Running a comparison between that advertisement and the regular content that you would see on the New York Times website, you see that the text is on a blue background, so it automatically looks quite different from the regular New York Times content. It's also hosted on a different URL. It's on paidpost.newyorktimes.com, so people looking at the URL would be alerted to it that way. At the very bottom of the advertisement, there's a disclaimer that says, this page was produced by the advertising department of the New York Times in collaboration with Dell. The news and editorial staffs of the New York Times had no role in its preparation. So it's a pretty clear disclosure, I think, even though it's at the very bottom of the article. The other point I want to make about this is that the New York Times has said that it will not share advertising content or native advertising content on social media in the same way that it shares its regular content. So these are visual cues that we've discussed. In addition to those visual cues, the FTC has paid a great deal of attention to the words that we use to identify ads. And during the forum, the FTC said, well, why don't we just call it all an advertisement? That's what this is. These are all ads. And some industry organizations have promoted use of words like advertisement, advertising, or special advertising section, and have discouraged uses of words such as promotion or advertorial. And the problem, I think, with this approach, in addition to the fact that it's limiting, is that it's not always appropriate to call something an advertisement. Sometimes that can be an oversimplified designation. Sometimes sponsored content is actually more accurate, I think. What I want to show you next is a chart that tells us how readers actually respond to these words, whether or not they understand that these words indicate that the content is not editorial content. The first thing that jumped out at me looking at this chart is that 30% impact is the top. That's where the chart ends. So the all of these are of questionable effectiveness, I think, generally speaking. But if you look at the words that are least effective, it's words like recommended for or suggested post, featured content. Those tend to not tell readers this is not editorial content. The most effective disclosures usually include the brand, either logo or the brand name in the post. And that way, regardless of what it says, whether it's advertisement or sponsored, it's clear that there is a company that's associated with that content. In addition to just saying sponsored content or designating the content as somehow not editorial, there's a suggestion to use a "what is this" icon right next to it. If you hover over that, that will explain to you what sponsored content is. And that's important, especially at this stage of the lifespan of native advertising, where readers might not be comfortable or knowledgeable about what the words mean, and they are sponsored is defined differently among different organizations. It's useful for people to know how that particular publishing company will define the term. And I'm going to leave you with one more example of how content is labeled. This is from Forbes, and what they do, instead of labeling it as sponsored or advertisement, they have a series called Brand Voice, and that's what they call their advertising content. They actually have a brief description of what Brand Voice is right next to it. It connects marketers to the Forbes audience, and also a more detailed explanation in the "what is this" if you click on that. And they include the brand that they're featuring right next to the Voice logo. So that's just one more example of how you can, how content is being labeled as advertising content. And I think we have a few minutes left for questions.
So feel free to send us any questions you have, and we'll try to answer them. I'll make one comment while we wait, which is it occurs to me that the question of labeling, whether you label something as an ad or as sponsored or promoted content, may also be giving a clue to the FTC. If you've called it advertorial, you really have taken away any argument that this is not commercial speech. If you call it sponsored content, you may still be able to argue that this should not be subject to FTC jurisdiction, that it's content that still belongs in First Amendment land. Do we have any questions?
And I'm checking the queue right now. I'm not seeing any new questions. We did have one person who asked if this deck will be available, and as we mentioned at the beginning of the program, that yes, indeed, we will make this available to anybody who has participated in this webinar. You'll receive an email after the webinar with information about where to locate the archived edition. Gareth, do you see any questions that haven't been answered?
I'm not seeing any come in the queue, and I'll just ask quickly myself, Rob, and Asya. And first of all, thank you. This was fantastic, and we got some great feedback saying that during the course of this hour. But if there's folks on the call thinking about just getting into this, or they're very close to getting into this, any resource you might point them towards, up to and including, should they be meeting with their attorney and reviewing what their policies and procedures are going to be?
A couple of thoughts. I don't know that there have been, and correct me if I'm wrong, Gareth, I don't know that there have been any standards set out by any of the newspaper organizations per se. Society of Newspaper Editors and that sort of thing. I think the ASME guidelines, American Society of Magazine Editor guidelines, are useful to look at. They don't apply wholesale in the newspaper context, but they're worth looking at and considering. That's one. Number two, the byword really, and you heard it from Asya over and over again, is transparency and being clear about what you're doing and operating with integrity, and I think that's what's really important. Does it make sense to sit down with a lawyer at the beginning of this, somebody who knows media law, knows advertising law, and can give you guidance on that? I think it does. It's not something you're going to need to do necessarily on a daily basis, but as you get started, to help highlight for you what the different considerations would be, I think that probably does make some sense. We have some clients who send us all of their sponsored content for review for that reason, but those tend to be clients with a lot more at risk.
Sure. Okay. Yeah, I think that's helpful.
Go ahead.
We did get a couple questions just come in.
We should add to that. I'm sorry, Gareth.
The FTC has a publication. They're called the .com guidelines, and those could be useful just to get a sense of what types of disclosures they promote, and they apply to all different platforms. So that those can give you some good ideas about how different options for making disclosures.
Okay, great, thank you. We've got a question, someone saying, can you revisit the percentage impact for the labels? I didn't catch the explanation of the numbers versus the phrases.
So higher up, or if you go to the right-hand side, recommended for you, suggested posts. Tell me if I've got this right, Asya. Those are the ones that are less likely to be viewed as ads.
Correct. The ones that are in the darker color are less likely to be effective, and the ones on the right-hand side, sponsored